Uh, let me just open the chat box and see. I think we're still okay there. If you don't want your name in this recording, you can rename yourself. If you hover over yourself up in the upper right hand corner, you should be able to rename yourself. Or I just want you to know that we do record these and put them up on our website for public availability. So tonight, you're going to hear from the entire Grow Midwives team. Joe Booth, who is my husband, if a lot of you don't know that, we have different last names, does a lot of the work around contract, employment agreements, vicarious liability, and general guidance on things that can help with business development and styles of business arrangements. Lesley, past president of the American Association of Birth Centers for 6 years, is going to provide a focus really from the employer side, having worked for others as a nurse midwife and now employs a fairly large staff at her birth center in Charleston, South Carolina. And you're going to hear me present a few redacted sections of contracts. We're now real close to 300 that we've reviewed in about just the 3 years we've had this business. And Joe and I looked at hundreds of contracts prior while I was teaching both at KU and at Shenandoah. So lots and lots of experience now, having a very clear balcony view of what's going on across the country, to be able to help you and give you a little bit more understanding of what's going on. So tonight, we want to talk about defining at-will contracts, and that's pretty much what everybody works in under in the U.S. Common clauses in at-will relationships. Lesley's going to share her perspectives as an employer and the type of agreements and expectations she has with her team. We're going to go over a few common clauses that we look at. All of this will be redacted, so they are real, but I won't know who they are. And then we're going to have a Q&A that really will spend time on what you're interested in. Why did you come? And do you have some specific questions? So what I want to share with you first is we're going to have 5 random drawings, and we're going to practice with the first drawing before Joe starts. There are 5 giveaways tonight, and if you're not interested in any of them, that's fine. You don't have to participate, but if you are, we're going to use a random generator by you putting your name and a number from 1 to 100 in the chat box. And the number that is selected by the random generator will determine who the closest number is that's the winner. And I'll keep track of those, and we'll announce the winners of each of these 5 items at the end of the 90 minutes. So the first one that we're going to do is a contract review. This is a professional review by Joe and I. We're looking at a legal lens, and we're looking at a professional lens. It's a written review. We return them within 5 business days. And we give you lots of advice on what to explore, investigate, prod, how to negotiate, professional issues that come up that I'm concerned about. And we charge $250 for that review. So if you're interested, put in your name and a number. And as Joe gets started, I'll go back in the chat box and we'll see who the winner is. We're also going to give away a 1-hour consult that can be with Lesley and I, with just Lesley or just me. It can be about any topic you want, anything from preparing for an interview to how to start a practice. We wrote a vicarious liability toolkit. It's the only item in our store right now that we sell. It is the most up-to-date document and toolkit on how to address vicarious liability in the U.S. with legal review of all cases related to midwives since 2019, I believe. That's a $50 toolkit that we're giving away. We have a cool Grow Midwives coaster set, and then a hand-turned Pinard, it works, that Joe makes, that often sells at ACNM meetings for over $1,000, even though it's probably not worth that. I'm sorry, Joe. So we're going to move on. If you want to put your name and a number in from including 1 to the number 100 for a contract review, do that now. And we're going to do that 4 more times through the night. So Joe, take it away and tell me when you want to move a slide.
Certainly. Probably one of the first things that I want to talk about is the idea that many people that we have consulted with believe that when they engage in an employment contract that's a 1-year or 2-year contract, that they have a guarantee of a job for a period of time. All of these contracts follow a common pattern, and it's really interesting how lawyers work off what is termed boilerplate, pre-written agreements that they pirate and adjust as needed. And it's very common for very early in the contract, maybe one of the first few paragraphs, to talk about this as a 1 or 2 or 3-year contract. And it usually also says it's going to self-renew unless you tell us in advance by some prescribed period of time. And so it just goes like a flat tire, in the sense that you hit that renewal period. If nobody is complaining and wants to continue on with the relationship, then it automatically re-ups. Most common would be 1 year, but we see 1, 2, and 3 all along. But if you go down 3/4 of the way through the contract and you go to the termination clauses in the contract, you'll find that we've never found a contract of the 300 we reviewed that didn't have an at-will provision that basically sets out what happens if you want to just quit or they want to just fire you without any reason whatsoever. That they just, like you quit going to Target and all of a sudden decide to be a Walmart person or vice versa. They just don't want to buy your services anymore. And those periods of time, the notice period of time, is usually a 30 or 60 or 90 day. So what you have when you have most of these contracts is that you've signed on for this contracted period of time, but anybody can quit. And the only reason why there's a notice period in there, or the primary reason, is to allow both sides an opportunity to prepare for the transition. And these agreements often say that once notice has been made, the employer gets to choose whether or not you're going to continue to work or not. So they could walk in on you 10 days after you've been in signed your contract and been working and say, it's not working out so much. Here's your 30 days notice. We really don't even want you to come back in the front door. Here's we'll pay you out for that month that we owe you, and you're done. And so those are often that's always how the context is. The only people that get these guaranteed periods of time are CEOs of major corporations and rock stars and sports figures. The idea of indemnification is it's part of, well, let me roll back. One of the reason why employers want contracts with employees is that it protects the employer's right in this employment relationship, and the standards that they care about are identified, and the rules are put in place. Whether that's a happy thing for everybody or whether it's protecting the employer, you'll find you'll never find an employment contract for an individual being employed by an employer where the contract isn't basically biased significantly towards the benefit of the employer. The function of that contract is to limit liabilities for the employer of what the employee does, and deal with some consequences if there's inappropriate behavior. So indemnification is the idea that if an employee does something for which they should be liable for, the employer gets sued instead, the employee agrees to cover for that liability. And this could be anything from egregious things like inappropriate billing and getting into all kinds of problems that way, all the way around to just simply any kind of work-based risk. and they're shifting the risk from their employer as an employer to the employee. So you have this burden sharing that happens. Then next you have conditions for termination, and what we see a lot in conditions for termination, like we talked about in the agreement, the effect for the amount of time, there's always some kind of provision that says the parties could mutually agree to terminate the employment relationship, or any party could unilaterally agree. And then there are certain factors that say you drop like a dime, you're done, and it would be things like committing a felony, losing your hospital certification, losing your licensure. These 4 cause lists are usually fairly long, and they involve a different standard in the sense that the employer has the right to just say, your employment relationship died the minute I saw you do that. Substance abuse might be another example. Then what happens when the employment relationship terminates? And this is something that we see tremendous variability on. And the 2 most common things that live on as a part of this contract after the employment relationship ends. So in other words, the employee is in a position where they owe the employer certain duties and obligations, even though the relationship has ended. And often, most often, these provisions are triggered whether or not you left for cause or not for cause, whether you're the one that quit or the employer terminated you. And we'll get into that a little bit more. Non-solicitation usually breaks into you promise not to try to pirate employees or clients. And so you're not out there soliciting patients. And this one can have an awful lot of empathy for an employer. They bring you in, you build a practice, you have a personal and professional reputation with your patients. They don't want you turning around and having used all their resources to then then just pick up stakes and leave and move across the street and start and take the book of business with you and try to do it on your own. And those are generally enforceable by the court pretty well by what they say. And there are usually conditions that are placed on that, such as a period of time, and it's commonly 1 or 2 years, and possibly a geographic limitation in the sense of, but more often it's a matter of if they were an employee or a contractor or someone, you can't go try to scalp them and bring them over to you. And patients are literally patients. And then there's some kind of time in which that relationship existed. The only thing that both parties need to be careful about when it comes to the non-solicitation is there's a difference between solicitation and a patient who willingly follows you as you move away. Because many people do. They develop a relationship with their midwife. They're in their last trimester. Midwife now is opening the shop, has moved across town, is working for somebody else. They don't care. They wanted midwife to deliver them, and so they follow them over. You can't impinge on the patient's right to choose who they have in these contracts. These contracts are just between the employer and the employee. Then we get into the idea of non-competition. And this is usually 3 criteria that are set that say upon termination, you promise not to work at some activity level. And for the purposes of this conversation, we'll say you promise not to be a midwife. And you promise not to be a midwife within so many miles of some location. And of course, the miles is always tricky if you're working for a hospital-based system or depending upon how it's phrased, whether it's miles from the office or miles from where you rendered service. Well, if you do some home births, you could have a scattergram in which you've got these dots all over the map, and you've effectively wiped out your community. And then it's for a duration of time. Most recently, and we'll have some examples here, but most recently we reviewed a contract that is in a rural area, and these are the largest community care centers in this rural area, and it said you can't practice within 60 miles for a time of 3 years. So someone who's already established in the community is being encouraged to sign this contract. And if they sign this contract, whether they work a day or 2 years or 20 years, they're effectively shut out of their own community and can't practice midwifery for 3 years after they leave the contract. Non-competition agreements of employees against employers are run afoul of the economic concepts of a fair marketplace. And so courts are usually given latitude to enforce the non-competition. But in the example I just gave you, they may say, we're not going to go for 3 years. We're going to enforce it for 1 year. We're not going to go for 60 miles. We're going to go for 5 miles because there are two communities that are neighboring communities in this hypothetical. We're just going to have an impact on one of those communities because you truly aren't being your legitimate marketing place. But some of these non-competition agreements not only throw all the fees on the person who is threatening breach, meaning you pay the hospital or the employer's fees, attorney fees, and all those costs, but we've seen some of them that have penalties of $10,000 and $15,000 agreed to in the contract. We're not a favor of non-competes. And if there is a non-compete, we believe that it's a reasonable stand to negotiate and say that the non-compete should only be effective if the employee is fired for cause or leaves for no cause on their own volition. But it's very hard to build an argument that it's very fair that an employer can hire you, let you work for a while, and then have the benefit of this non-compete and knock out professionals in the marketplace who no longer can compete with them because they just simply fired them for no reason whatsoever. You could see that if somebody wanted to bring on, if there was a competing set of midwives, hire all the midwives from the other competitor, then fire them 60 days later for no other reason than the at-will provision and feast off of the non-competition agreement.
Joe, I want to say here to our listeners, we have an entire 90-minute webinar on non-competes that's available to listen to on the website. Yep. So there's a much bigger conversation than what he's hitting on right now.
And then the contracts usually try to talk about protecting the employer's property, and the property can be intellectual property. Assure the employer that you're going to follow through with all the confidentialities that run the whole range from lists of patients, patient information, which is of course also covered by other law, and even just how they do business, so that the employer is protected by inviting a professional into their fold, sharing an intimate relationship, and then when that professional chooses to leave, that they aren't somehow losing the intellectual property. And I think that's it for that little slide. The permitted and prohibited activities usually means they define the scope in which you're going to work as an employee, sometimes with limits. You're only going to offer midwifery services, or you're going to dedicate 100% of your professional activity to this practice, and therefore pull yourself out of anything else. If you want to teach on the side, if you want to work in some philanthropic, like a community care area or anything like that, you're prohibited from doing it. And they usually say you're prohibited from doing it unless you talk to us about getting permission. And then they turn around and also say that one of the obvious concerns is once you're insured, and the employer generally carries the malpractice insurance. We'll get to that here in the next bubble here. Once you're insured, you're insured no matter where you went. So you're incurring liabilities on a policy that the employer's paying for. And what they don't want is for there to be additional malpractice risk in activity that they're not in the business of, that you're doing it for somebody else. You're doing a home birth for somebody out in the community just because you enjoy doing that, or their peers or something. And the employer has a right to have a voice in that through these clauses. That's where they get that right, the contract. Remedies for breach of contract can be everything from the contract itself states what the breach would be through to liquidated damages. And what I want to talk about there in liquidated damages is, again, like I talked about a moment ago with the non-compete, is you're winding up with an obligation, and we've seen these at $15,000. If we find you violated the non-compete, you just owe us a check for $15,000. We don't have to prove anything else. Once we've proven you violated the non-compete or whatever it is. And then there's usually other clauses that include fee shifting. Either some of these contracts actually say, if we get into any kind of litigation, you pay for all the fees, whether I sued you and I'm right or wrong. Some of them say the prevailing party pays fees. And of course, when you have a contract that's filled with rights of the employer and very few rights the employee has, it's almost hard to have a conflict in which you're not the prevailing, in which you are the prevailing party. Next, I want to talk about malpractice coverage. The average claim for damages or settlement is somewhere in the neighborhood of 1.1 million in midwifery and obstetrics. That's the average. And I'm not sure how solid that statistic is. We just keep hearing that same statistic as we do our research. Most policies have a coverage limit of 1 million per occurrence and 3 million aggregate. And what that 1 million, 3 million means is, if mom sues you because she felt like she suffered malpractice, she can get you have coverage up to 1 million. If she gets a $1.5 million verdict, she has every right to go after you for the other $500,000 that your insurance didn't cover. The aggregate means that if mom and baby both have similar claims and they each have the damages, and mom gets 1 million and baby gets 500,000, both of those are covered because it fits within the aggregate. To deepen the problem of talking about malpractice coverage, there are two main types of malpractice coverage. One is claims-based and the other is occurrence. Occurrence policies are more expensive because they say, the insurance company says, if it happened while you were insured, we're going to cover it. So if you are working in year one of your practice and an error or an omission occurs, and when the child turns 19, they file an action and pursue the claim, that year one insurance is still effective, even though you may have left that company so long ago you can't even remember its name. Claims made is when a claim arises, you have to have this continuity between both when you were covered by insurance for the breach and when the insurance company is made aware that there's a claim. And of the things that are very important about that is that, and contracts sometimes cover this as a contractual duty as well, is that if you're aware that something happened that could become a lawsuit or a claim later, you self-report, and that locks in that insurance policy. But otherwise, as soon as you leave employment, a little bit like your car insurance, you have no more insurance. And that's where the concept of prior acts coverage or tail coverage and having other insurance pick up. And so without getting too deep into malpractice coverage, that's where we are. And we often review the contract and try to find out if the employer is offering a specific kind of insurance, what type is it, what the limits are, And then we advise people that sometimes getting this excess coverage is not that expensive and not that bad of an idea, to make sure that you don't have a claim that reaches over that limit. And we usually ask people to try to get as much documentation as they can over the insurance. Different entities cover insurance in different ways. But then you get into the concept of tail coverage. And I don't think we have a specific bubble on the slide for this.
We don't, but Joe, we do have a 90-minute session that just talks about professional malpractice coverage. So,
all right, we'll go with that.
Yeah.
And then resignation notice clauses. It's not really resignation notice clauses, it's notice for anything in the contract. One of the things that you really need to do if you have an existing relationship with your employer and you have anything serious to discuss about the contract, you need to go back to your contract and find out exactly what are those rules on how you give notice. Because we often work for some administrative leader, a shift manager, someone who's called to manage the midwifery group, whatever that is. But the contract may say you have to notify the corporation, a specific person in the corporation, and in specific ways. Often it's registered mail, FedEx return receipt, email, something like that. But there are rules to this game. And if you're trying to protect your right underneath the contract, you need to actually read what that notice provision in the contract says. And you're going to usually find it in the last 2 or 3 pages of the contract, and be able to follow those rules of the game. Because otherwise it's a little bit like you had hail damage and you told your next door neighbor that you had hail damage, but you didn't remember to tell Jake from State Farm. And then you haven't actually made out a claim, or probably literally, if you tell Jake from State Farm, you still haven't made a claim because you're supposed to be talking to your agent.
Okay. We're going to come back to some of these topics that Joe just discussed with redacted examples. So that's sort of why I shortened Joe a little bit, because I'm sure he's going to come back and help in some of these that we're going to give to you. So we're going to take a moment, and the next item we're raffling off is the Vicarious Liability Toolkit. This is a 22-page PDF toolkit that Joe, as a primary author, and me as a secondary author, prepared for purchase. It helps in discussions that are led by physicians who say, I can't be your collaborator, or I'll incur vicarious liability. My malpractice coverage will go up. Or physicians who try to create barriers in conversations about why scope of practice are issues within a state. Joe really is the most recent author in the Journal of Midwifery and Women's Health, and that was a 2019 publication that we simply updated. So if you're interested in the Vicarious Liability Toolkit, put in your name and a number, and then we're going to move on. And Lesley, I'm going to let you take over.
Hello, welcome everybody. So I just wanted to start with a couple of facts about South Carolina employment law. We're what they call a right to work state, which just means it's not union friendly. There's no minimum wage set for South Carolina, and we are an at-will state, meaning that either the employer or the employee can leave the employment for any reason. There does not have to be cause. Of course, certain things are always still included in that, and that would be like the anti-discrimination. You can't be fired because of your race or your religion, or etc. We do not have any tort reform laws, but it's also not a very plaintiff-friendly state, meaning that very few med-mal cases are won in very large amounts. And there has never been a case in South Carolina where a certified nurse midwife and her OB consulting physician were sued and lost yet. Collaborative now that doesn't mean they didn't settle, before it went to trial. Collaborative agreements or a policy and procedure with our referring OB are required for CNMs. That's new. We were a supervisory state up until a couple of years ago. So we do have a clause written in there that CNMs do not have to have a written collaborative agreement. They just have to have a policy and procedure of who they would refer their patients to should they need obstetrical care. There are very few CNM-owned practices. Mine is the largest as a birth center. There's a couple of midwives that have private practices where it's just themselves. One is a home birth practice, one's a hospital birth practice. So letter of agreements versus contracts. I'm a small employer, so there's a big difference between being employed by a small employer versus a large corporation, which is what most of the hospitals are. I mean, there's virtually less than a half a dozen or so big corporations in this country that all the hospitals are owned by. So when you go to work for ABC Community Hospital, it's probably owned by HCA or Tenet. So you're joining a very large corporation, bigger than many that you would think of, like Boeing or something. And the HCA is the largest hospital corporation in the world. So it's a big corporation versus you work for a birth center that's owned by a midwife. So there's giant difference between those. So most smaller employers don't have contracts. We try to avoid lawyers. Sorry, Joe. You know, they earn their money, and we don't want to pay them. So we try to work things out on a smaller scale because we're smaller scale. So what we do here is we just have a letter of intent. I'm offering you this job for these hours and this pay and these benefits. And here is the job description, and you agree to accept the job or not, knowing that you could be terminated at will, and I know that you could leave at will. Employers invest a ton of resources in a new employee. So we really don't want an employee to leave after a year or two. I mean, really, we want you 5 years and longer to really be able to get a good investment out of you. So don't be afraid to turn down a job that you feel is not right for you, because your employer doesn't want you either. If there's something in your gut is saying, I don't know about this, keep looking. Variation in terms. I think that's kind of what I just hit on, Ginger. I'm not sure what that meant, but there's a couple of things. I made a couple of notes about my perspective from some of the things Joe said, that non-solicitation and non-compete are completely, totally different things. And so as an employer, I'm very pro non-solicitation. In other words, you can't print out the list of patients due in the next 9 months with their names and addresses when you leave here and send a letter to them saying, I left and this is where you can find me. I would sue you over that. I think non-competes are kind of sleazy, and I would never ask an employee to sign a non-compete. So I have like very strong feelings about both of those opposite ends. So just know that they tend to lump them together under the same paragraph in a contract, but they're really, really different things. Working outside of your employment, I do not allow that because I am paying for your malpractice for the same reason Joe said. And if I don't want to pay for a liability that I don't have any control over. Now, that doesn't mean that you couldn't get a job doing something that is not a midwife job, but not working as a midwife. Med-mal. Tails are tough. They are expensive, but it's a negotiation point. I don't offer a tail from the beginning, but I might negotiate a tail if there's somebody that I really, really wanted to hire. What we have found recently, and I think this may just be because midwives it's easier to get med-mal insurance for midwives now. It used to be very few companies covered midwives, but now many do, and many more are starting to. When I've hired a new employee or an employee has left, we've been able to negotiate whoever the previous or the following employers, their malpractice picked up and said, we're going to cover all. So there was no tail. So that's a good thing. I hope that trend keeps happening. So we have not had to pay a tail yet. The 1 in 3 million sounds like a lot of money. It's not. If you're in a case, especially a complicated case, those cases get drawn out for years and years and years and years. And lots of experts get hired, and you can spend your $1 million before you ever get to trial. So you can have no money because it's all spent on your defense before you get there. And that is not an uncommon occurrence. So midwives tend to forget that that's also part of that $1 million. It's not just what would go to the family. When you're a professional now, as a CNM, and professionals, it is expected that you would give a 90-day notice. So a 2-week notice like you might have in a previous job would not be considered a professional way of leaving. You would leave a bad taste. You would not probably get a good recommendation if you did that. However, you also want to be sure to keep in mind that the day you turn your resignation in may be your last day working. You might give a 90-day notice and they may say, thank you, but no thank you. And it may not have anything to do with you or your relationship or anything. It's just that having a lame duck employee can not be good for the morale of the rest of the staff, for having somebody there know they're leaving. So many times, unless I have an employee that's leaving because of retirement or pregnancy or a change in career, I don't usually allow I expect them to give me the full 90 days, but I don't always go for the full 90.
You know, Lesley, it's interesting. About an hour before we came on, a midwife called me, and I'd be interested in hearing you and Joe's comments about this. It was about leaving. She had been there 6 months, new grad, first job, was not at all what she believed it would be. And about 30 days ago, she and another midwife were asked to sign a new exhibit addendum to the contract that said they had to give 90 days notice. There had not been a notice clause in the contract prior, and they signed it. And then in the last week or so, the office manager came and said, oh, I'm sorry, I made an error. The doctor said it has to be a 6 months notice.
Wow.
And this person is like, I'm out of Dodge. You know, this seems, she didn't want to be there anyway. She knew she made a mistake, but now what am I going to do if I'm unwilling to sign this in front of me on my desk? And yet just 30 days ago, I signed one that said 90 days.
That's a tough one because finding somebody to replace them is hard. So when you're in a smaller practice, like maybe just a physician practice, as opposed to working for like a large hospital, it takes way longer than 90 days to recruit, hire, and train somebody. You know, I've had one employee that gave a 90-day and asked to be let out early. And I told her, well, you can leave early, but if you're asking for my permission, I say no. It's already, you know, I'm going to be in a lurch for a while without you. And her leaving also corresponded with somebody out on maternity leave. So I was like,
yeah,
heck no.
Well, the question becomes, and you know, Joe, I don't know if you want to take a stab at this because of course we don't have a contract in front of us, but she couldn't find anything that said what the consequences were, no breaches if she did leave at 90 days versus 6 months. Other than the guy may just say, she's a horrible midwife, she left and didn't give me adequate notice. If a referral would ever, you know, be asked of him.
the fact pattern brings a number of problems. Restrictions on an employee through contract are pretty enforceable if that's the deal you sign on to when you begin your employment. But especially when you talk about notice provisions, it would be one example, but even more importantly, like a non-compete, unless when you look at non-compete law, you're going to see a series of cases in which employers decide, after there's an employment relationship, they decide to pass around this agreement and ask you to sign it. And then the question is there a fair bargaining position for that? Now, two different scenarios that give,
Because you're already employed, and now they're asking
right,
you to change.
right. So you're simply obeying your boss at that
right.
time,
right.
and it's not a fair market relationship.
Right. There may be some listeners on here very interested
yeah.
in what we're talking about right now.
Yeah. So there's questions on whether a court's going to do anything to enforce the 90-day that they had thrust in front of them. There may not have ever been any words like, if you don't sign the 90-day notice, we're going to give you tomorrow, and you're out of here. The scenario is unlikely because they're scrambling around trying to make sure that their midwives, or whatever that employee status is going to be there, and that's exactly what they're trying to guarantee. But there's still a veiled threat there. You're being told here's a new rule that you didn't have before. And so the employer's got a real serious problem for enforceability. If the contract doesn't state what the terms of the breach are, what the damages of the breach are, like I didn't give my 90 days, you could see claims for bringing in a locum tenens to cover your call for the 90 days that you dumped them with, which would be a huge bill. Might be similar to 6 months of your salary. Or other different claims that says this is what I was damaged by, or just simply demonstrating that maybe patients had to be referred on, and births that were scheduled to be in-house had to be handled by some other practice, and calculate up those losses, and they could be appreciable. So the fairer the situation is, such as you, in order to get this job, you agreed to do this, the more likely it is it's going to be enforceable.
Thank you, Joe. Lesley, I didn't want to sidetrack you there,
That's okay.
but I did want sort of to give that example, since we were talking about this issue of notice and what's really fair to the employer. I mean, you gave a great description of why it's so important. To get someone hired, relocated, credentialed, it's easy 3 to 4 months.
Yeah, that leads into the next one, is the protection of the employee. That's a balance. And so that's what you want. You want the contract to be balanced so that it doesn't tip too far either direction for both of you. As far as questions to ask, I would say the biggest one that people I see over and over make this mistake is they look at benefits and money and don't look at the time. And your time is going to be way more valuable to you than the money and the benefits. I promise you, without a doubt. People will leave jobs and take jobs with less money to have more time off. So you really need to be specific. If what does 1 in 4 call mean? Does that am I on call? Do I come into the office when I'm on call? Do I get the post-call day off? How many days in a row can I expect off within a month's time? Do you only ever get 24 or 48 hours at a time, and that only comes post-call? That would stink. So the hours that you're expected to be on call and working, and your clinic hours need to be very, very clear. And that's where so many people sign up, and then they start and they're just, cry themselves to sleep the first 2 nights, wondering what the heck did they just get themselves caught into. But there's also something I call first jobitis as a new grad. You are going to be a little bit of a deer in the headlights for the first few months, and expect that. The job's going to seem overwhelming. And that's only because it's new to you. You're the new guy. First of all, you're nervous. You've got all this new responsibility. You got new people to get to know. You got new policies to get to know. And even though you're knowledgeable and skilled, especially as a new grad, you're going to feel like maybe this is not the best job for you. Give it time, because it's a very common reaction those first few months until you can find your niche in this new family system. Some other pieces of advice, and not maybe necessarily questions, would be, if you're considering leaving your job, don't tell anybody. It's going to get back to your employer. I promise. There is no gossip line that is faster than medical gossip lines between hospitals and practices. And you can work at one hospital and it's a whole different hospital system, and in 3 days everybody there knows that you're looking around. So you need to keep that to yourself. The things that you want to look for in job offers. So I'm going to sell a little bit of working for somebody small. Yeah, you're going to go work for a big corporation. You're going to be enticed by the money and the benefits. Without a doubt, I can't compete with the money and the benefits that a big corporation can offer. That doesn't mean I don't pay fairly or that my employees don't have benefits. But what I have to offer that they don't have is you have more autonomy. You have more of a work family. You have more say in what your future is and how the practices run. And you generally will have a better life-work balance than you would in a big corporation. So I would, if you're looking, be sure that you don't just automatically pass up a job because of what the salary range is, because the job itself may be that is going to fit you better in the long run. And I think that's everything.
Yeah, Lesley, I'll tag on that in a lot of the coaching that I've been doing, both with small home birth practices, birth centers, large tertiary care centers, academic centers, and of course, the big giants. What I try to say is, what do you want and what do you need? And we actually have a webinar on that as well. We've really been working hard this year to help midwives navigate what is your worth. And you've got to sort of decide what do you want in a job, and what do you need for yourself and or those that you have to contribute your job choice to. Do you need health insurance because of X, Y, and Z? You need to make X amount of money because of your student loans, whatever that might be. And then think about these jobs in terms of fit, the philosophy, the feeling of being included, the diversity, the recognition and importance of all team members. And that takes some skill in interviewing, because it's not just them interviewing you. You need to think about you interviewing them and make that decision be a decision you're willing to stick with for a while once you make it.
I can give you an example. My son-in-law, who just recently started his first job out of fellowship as a physician, he's being paid big bucks, but boy, is he putting in the hours. And, I'm watching him thinking, oh my gosh, it's tough. It's really tough, the amount of hours he's having to put in. And, we were having a conversation the other day, and I told him, I said, that's why I have such a good schedule for my employees. I can't pay them the big bucks, but you know what? I give them a 3-day weekend and a 5-day weekend every month. And he told me, he said, I would give back a lot of money to be able to have that. So that.
Yeah, and you can prove it, Lesley, with the longevity of your staff. It's remarkable, the longevity that you've maintained in a birth center. Really is a benchmark model. So let's have another raffle. And to clarify this, each time, if you are interested in the item, put in a new number, 1 to 100. This is a Grow Midwives coaster set. We put these up just for fun last year, I think. Sold them out of Etsy. They were really popular for a while. We're not into selling and marketing things, so we're not big pushers. But again, these are done by Joe on our laser. They have some cool midwife sayings on them. I think there's 8 coasters in the set. And they come from Grow Midwives. So if you're interested, put your name and number up there, and I will remind you, you only get to win 1 item tonight. So we'll make sure that happens. So I'm going to take it from here, and I'm going to involve Lesley and Joe through these conversations as well. What about these offer letters? We've been seeing offer letters, and a midwife will call us and go, oh my gosh, I got this offer letter and I'm ready to take the job, and this is what we agreed to, and this is what happened in my interview, and I signed it. And then they go, oh, but I'm supposed to get a contract in a week. And so it's almost like the analogy of being an athlete. I'm going to use Krista, your daughter. I don't know if this happened to her or not, and being signed to go to a university because of her athleticism and her skill in weightlifting. And so you sign a letter of agreement that you have pledged to go to that university. So you are basically giving a verbal commitment that you're accepting an offer to work for them, but it's not the contract. And so what happens when you sign an offer letter and then you see the contract and you go, oh gosh, this isn't what I thought I heard, but this is now what it says. And so, Joe, will you speak just a few minutes about the difference and which sort of has more power over the other?
Certainly. Let's think back to what a contract is. And it is an exchange of promises with some kind of consideration involved. So you tell the boy next door, if you mow my lawn I'll give you $15. If that little beggar goes out there and starts mowing the lawn, you owe him $15. And that is a contract. It doesn't have to be written. None of these contracts have to be written. The offer letter sketches out in more detail the mutual expectations, and it is evidence, and it is a contract. So if you have an offer letter that says, if you come to work for me, you're just like the little boy who mows the lawn. If you start working for them, the terms that they set out in that offer letter are the terms of the contract. Now, there are nuances in that there may be memorandums of understanding of what we're interested in, and the language within this letter and within the dialogue and whatever you sign may not be a commitment. It may say it's not a commitment. It's a negotiation step. Car dealers love to do this. They get you to sign every piece of paper they hand in front of you, so that you get so used to signing that by the time they hand you the fact that you're going to pay more for the car than you did your house, you're standing there ready to sign. You're also a little sick of signing stuff. But each one of these steps is in essence an agreement. Offer letters don't tend to have consequences written into the offer letter. They don't have non-competes. They don't have non-solicitation. They have, this is what we're offering you if you'll come to work for us, and this is what we expect of you, such as hours, maybe, it may not be that clear, yeah. Role of midwife, that kind of thing. But when it clearly says, here's what we're willing to do, and this is kind of the structure of what we're looking at. In other words, we're going to pay you $75,000 a year or $150,000 a year or whatever it is. And it's testing the waters to see if you're serious. And then they're willing to go put together a contract, which may be something that's in the drawer that they're going to pull out and put your name at the top. Most of the contracts we see are clearly recycled. Sometimes there are typographical errors where other people's names are in the middle. and then they start offering the contract. Under contract law, the last document you sign erases the history of everything in front of it. And so what you have is a situation where if the offer letter says you get a Cadillac Escalade to drive back and forth, you get, you know, a gold cell phone and $125,000 a year, and we'll pay your student loans. And then you go, oh, I like this job, I'm going to go for it. You get the contract, you read through it, and the contract promises you $125,000 a year. They'll reimburse you for some of your cell phone coverage, and they really hope you pick out a Cadillac you like because you're going to use it out of your salary. That last step is what is the enforceable part of the agreement. It erases everything in front of it. So when you have these documents that memorialize what happened as you move forward until you made the agreement, they serve no purpose other than that moment in time before the agreement came. And under contract law across the nation, if you sign a contract that says this is our entire agreement, and it's, you got to look at the four corners of this agreement, the previous documents that came in cannot, as a rule of law, be considered in interpreting what this contract means. And so some of it is just simply staging, gamesmanship, the courtship of employer to employee. And I'm not saying that nefariously. Lawyers constantly negotiate this way. You know, okay,
But
so is this what I understand?
But midwives don't. That's their point.
Right. So we're constantly saying, well, if the contract looks like this, would you like it? And you write out whatever you want as a memorandum of understanding. And you know, you're asking to cancel the hearing tomorrow. If we can come to these terms, we don't need to have our hearing. And if we can agree on what those terms are, then we're going to go write the contract later. Divorce settlements are exactly what I do all the time. And it's nothing uncommon for couples to, as a matter of fact, it's most common for couples to face a divorce hearing and decide that they can figure out their own problem and cut the risks and the cost of the trial. And they describe what it is. You keep the house, I keep the car, you know, we throw away that third kid because we never were sure about them, that kind of thing. And and describe it in general. And I gotta have comedy sometimes.
I know.
And describe it in general, but then the devil is in the details. And these employment agreements carry all the details that are in the agreement. And if you ever promised something in an earlier document, if it's not in the agreement, it's gone.
Well, and so one of the things I tell people is that's exciting. They want you. Use it as leverage. If they're offering you something in a letter, then they're extending a hand saying, we really like you. And to me, that should be your response, Erin. Okay, now we're going to start talking about what I want. And that's where negotiation comes in. It doesn't mean you're stuck with what that offer letter says. It means they want you. So let's look at some sample agreements, and we're going to talk a little bit about suggestions we give from a balcony view on negotiation points, because oftentimes we're looking at the details, and that's how we sort of guide people on, well, maybe this is what you want to come back with to try to make some progress on this. So you've heard all these phrases before. We're bringing them back out again with examples. Can you see those without the discussion, the chat board in the way?
If you're having trouble, you can move your chat board by clicking along the top of the chat board.
I'm trying. We've had okay. So here's a non-compete. And these are contracts we've reviewed, remember. And this was actually the one that Joe shared, which I didn't know he was going to share. We just looked at this one within the last week, and we went, oh my gosh, this is the worst non-compete we have ever read. So 3 years after the employment is terminated for any reason, with or without cause, including the expiration of the term of the agreement, while not within 60 miles of the city or state, engage in the practice of the midwife's specialty. And that literally would knock her out of the community in which she lived, in which she established a birthing center, and would be life-changing to this individual. And so what do we suggest to her? So here's some ideas based on the geographic region, the number of miles, and the scope of what they are trying to restrict you from doing. So Joe said this a lot. It's important to keep saying that you suggest back to them that if you're terminated without cause, they're just done with you. The non-compete would not apply. It's a very simple thing to ask. And sometimes we're finding out that the physicians or the HR person has no idea what these contracts say. They're just slipping them across the desk in front of you or by email. And when you come back and go, this really doesn't seem fair to me, how would it feel to you if you were given that kind of a non-compete? And they'll go, I didn't even know that was there. And they'll strike through it.
Yeah, this is really happening, especially you have a smaller practice, like what Lesley described herself as. They contact some attorney and they say, I want a really strong employment agreement. And they get back this employment agreement and they're doing everything else. They just have their employment agreement and it gets piped straight to the employee. And they don't know that there's a lot of this stuff in there.
Yeah, we've
and
had
so
that multiple times.
Yeah. So don't respond with the assumption that there's an evil intent behind the offer, and either just don't suspend negotiations or don't want to talk to them
or
in
jade
a
your viewpoint
respectful
about
way.
them. You
Right.
presume somebody's characteristics and they in fact didn't have anything to do with it. It can be a problem. Reducing the time of the restriction. You could have 2 babies within 3 years. It's really ridiculous. So we've suggested sometimes to bring it down to 9 months if they're worried about losing maternity patients, to use that 9-month cycle as a reasonable period over years, to reduce the geographic region. And this can be tricky based on whether it's rural, urban, semi-rural, semi-urban, but certainly trying to reduce the geographic distance if you're not going to leave the community. And this one also can be of value, but I don't get a lot of feedback in knowing how negotiations went for people. I would love if we could get that feedback, but suggest that if you practice in a different non-like setting, that it does not apply. And I have seen some from birth centers that say you can't practice in another birth center in a 60-mile radius, right? And that would seem reasonable to me. But if I leave Lesley's birth center and I want to go work in a hospital and I'm not competing with the same kind of patients, right? That's a different employment setting that would not likely be competitive. So maybe you're going to go to a federally qualified health center, and where you've been working is full of private pay patients. That is not a made-up case. It's a case that happened in Florida with 7 midwives and WHNPs. We reviewed that case on the non-compete webinar and what happened to them. They left a private clinic. They went to go work at an FQHC. There was a cease and desist order, and they were without employment for quite some time. It's a fascinating case. It didn't happen that long ago. Or what if you want to go work in a free clinic and you're not even remunerated? If it says you cannot practice as a midwife, it doesn't say you can't practice as a midwife if you're paid. It says that you can't practice as a midwife. So, I have a friend that works at a free health clinic in rural Kansas, and gets the tort claims for the state, pays for her malpractice, and she's volunteering as a midwife. So the longer you talk about this particular discussion, the more likely two things are to happen. One, it will modify or not. And two, you're going to know who you're talking to and the kind of personality and trust and non-trust and fears that they have had or not had that may influence your decision about whether you want to work there.
One of the biggest hints that you have when you look at these contracts, you would expect to get back, oh, these contracts are the same for everybody. If you get into the structure of these contracts, very often it's the most common thing is that the compensation package is actually an exhibit added to the contract and referred to within the contract. So we're going to pay you, see Exhibit A. And the whole purpose for that is so whoever writes these things doesn't have to go back and fix all kinds of references in the contract. They can change Exhibit A on the fly. And we see a lot of non-competes and other portions of these things that actually have within them, they're off in the exhibits, which means they're not only can you change the four corners of this contract because it's just a piece of paper, often we get them to review in Word, but you can change the exhibits because that's why you use exhibits. That's all I had.
Sure. I'm going to speed it up a little bit because I want to make sure we get all the way through and there's time for some questions. So I'm going to hit the highlights here because Joe's talked about malpractice coverage, but here's an example. The employer shall purchase and maintain at its expense. So they're going to buy your malpractice insurance as they deem appropriate, which means absolutely nothing to you. You don't know if it's claims made. You don't know if it's occurrence. You don't know the limits. And they may decide that they're not going to give you full coverage and not tell you what the limits are. The form and the amount is determined by the employer at their sole discretion. And this is what's really interesting. Upon termination, employee shall purchase at her own expense tail insurance coverage. And several contracts we see says that you have to prove to them that you've purchased it, or even worse, they're going to purchase it and you're going to pay for the policy they picked out.
Which will be
Now,
like the tens of thousands of dollars. We're not talking about $1,000 check.
That's right.
We're talking about a $30,000.
That's right.
Well, in this contract, if you're negotiating, go back to that slide a moment.
We're going to get to negotiating.
Well, go back a second. This is an example of what kind of a three blind mice contract, because it's so vague that even their guarantee that you purchase tail doesn't cover the variables of what the tail would be. What limits are you going to buy? For what period of time? You could get minimalist coverage to satisfy this. So whoever drafted this language didn't think all the way through it, and you have a bunch of mush there. And that's an excellent, as we segue into negotiations, a way to say, look, neither one of us know what we're promising each other.
Yeah. So in negotiating tail, one of the things that Joe highlights all the time, and I think we've said this, if you're fired without cause, to ask for them to cover the tail. And there are benefits to them covering your tail if they were your employer, because they are vicariously liable for the work that you did for them. And if you want to learn more about vicarious liability, we have a toolkit that talks about that. It's an employee-employer relationship. It's not anything about a collaborative partnership or scope of practice or anything else. It's who do you work for? And what's interesting is recently, I've now seen 3 or 4 of these that have popped up very recently, that if you stay for X number of years and you're dedicated to the team, then this is the portion of the tail we will pay. So it's sort of a shared cost. And as Lesley said, depending upon if there are any facts that may show up down the road, or if you've been practicing a long time, or if you're in a region of the U.S. where liability is high, we're talking $20,000, $30,000, $40,000 for tail. It's a big deal. Malpractice coverage insured.
I would add one thing.
Uh-huh.
Many of the contracts we are reviewing, and Lesley touched on this slightly, many of them are requiring you to show that you have prior acts coverage or tail coverage that covers all of your liability before the first day you start employment. So this tail conversation can be not only a liability question and whether or not you're going to pay for insurance to cover some risk, but it can also be an employability issue.
Yeah, I talked about that earlier tonight with the midwife that got me on the phone, which was having to prove your coverage before the next employer will hire you, or the next hospital will credential you. We've talked about this insured limits several times now, so I don't want to get caught up here if we can get to the questions and have at least 15 minutes a little bit sooner. But to say they're going to cover in the amounts that are customary and professional standards within the medical profession, I mean, this is just another example of a vague coverage statement. And three points we want to say here, and I'm going to say it faster than probably Joe would, which he talked about what's the average. I know you're laughing at me. The average payout at about 1.1 million. There are a growing number of midwives that are asking about another layer of coverage. And they may sell another policy, umbrella policy, to you for a reasonable rate to get a little bit higher protection. We recommend that you contact the insurance company the employer uses and ask them about what that might cost as an additional layer. And tonight I was talking to the midwife about, you're going to leave. Do you have a copy of the policy? Have you read the policy? Is it in your file? No, I don't even know where to get it. You need a copy of every policy you have ever had in your professional career, your entire career. So if you don't have a copy of your policy now, go get one. Let's go through remedies of breach pretty quickly, Joe. I don't want to get too caught in arbitration here, but if something happens and you breach the contract, or you believe the employer breached the contract may say that you can't take this to a jury trial. You have to go through arbitration. We don't see a lot of arbitration, Joe, as I recall. Is that true?
We see quite a bit.
Okay, we do. It's just not written as this one is, maybe.
We see, if you're an employer and you're dealing with bringing people in and working with them, and you want to protect your good name, one of the ways to protect yourself is to say we're going to have binding arbitration. The arbitration is going to be private and confidential. Arbitrators are private judges. I'm trained to be an arbitrator. I don't do very much of it, but they try to seek an agreement between the parties and act like a mediator for a while, and then they hear evidence and make a decision. And because it's a matter of contract and sometimes statute, the arbitrator's ruling will only be overturned by a judge if there are very, very special and egregious circumstances. So if you have a claim and you're angry about maybe how bad the standard of care is, maybe it's a mix of very inappropriate harassment and other issues that you have within your claim, and are suing on the breach of this employment agreement, you may not get a public hearing. You may not get a jury trial. If you've agreed to alternative dispute resolution in arbitration, that is going to resolve that claim, and it will be in a Maxwell Smart cone of silence. Mediation, on the other hand, is an alternative dispute resolution process in which the dialogue that happens within mediation is generally statutorily privileged. It isn't going to get out, but the mediator can't make a decision. So if mediation fails, both parties are sitting there worried what's going to happen if this gets public, and a little bit of a fight here. So arbitration clauses are important. Arbitration has many positive aspects. It's faster, it's cheaper, it's efficient way to resolve things. And you too might not want your dirty laundry aired in this dispute between employer and employee.
And so the cost of that, who pays for the cost of fighting a breach, can depend, but it typically favors the employer, as Joe said earlier.
Correct.
And so fee shifting clauses are very common in what we read, and it basically says you're going to owe them for all the costs incurred to fight them. It's rare that we don't see that.
And that means that they're motivated to hire 3 lawyers at, I charge $400 an hour, and knowing that the odds are spectacular that you're going to wind up with a judgment against you. Their only reason for not hiring 5 lawyers is that they know you are going to be broke by the time this conversation's over and you're going to be judgment proof.
Yeah. So midwives are walking away. So it's important to know if that's what you're agreeing to, and whether or not it's possible to negotiate that. Okay. So before we do a slight little advertisement, here is the next item that is a 1-hour session with Lesley, with me, or with Lesley and I. We do charge $250 for an hour. And if you're interested in this raffle item, put in your name and your number, and we will figure out how to do that with you. And then while you all are filling that out, I'm going to hit the random generator and talk about what we do. So this coaching is anything from how to negotiate, prepare to interview, a practice that wants to talk about negotiating as a group, somebody that wants to start an independent practice, somebody that wants to start a birth center. We're really willing to talk to you about anything in that hour. The contract reviews we've talked about. We are working with a fair number of practice settings in terms of practice development. We have a physician and a midwife we're visiting with on Friday about growing a midwifery service. We're very interested in helping get midwives excited about starting their own private practice, birth center, or alongside units in hospitals. And the other thing that we've been working on now more and more is working with universities starting midwifery education programs. We're formally engaged with 2 universities in the U.S. starting midwifery programs, facilitating legislative work, which Lesley has a tremendous amount of experience in. We do a fair amount of teaching across the U.S. and grand rounds and speaking. So I am going to stop there and see if you have any questions. And then at the very end, we'll do the very last item, which is the hand-turned Pinard that you might be interested in. So let's open up the mic. I'm going to try to pull up everybody's picture here so I can see you better. And we'd love for you to turn on your video and turn on your mic. And if you've got some questions, please ask. Don't be shy.
While we're waiting on questions, I would just like to emphasize, don't be afraid to negotiate. Your employer is expecting you to not sign the first thing that they offer. We kind of hold some things back so that we have some wiggle room for negotiating. So it's expected. So don't feel like you're being rude or not respectful of their offer if you negotiate.
It's great to hear an employer say that, Lesley, because it is not common. It is not common for midwives or seasoned midwives to feel like they have the power to negotiate. Other questions? Yeah, go ahead, Christy.
Okay, I had to find unmute. So question for you. I'm currently in a contract. I've been here, all of us have been here for a pretty long time. And now they're talking about rechanging all of our contract. Is it, to changing our pay scale and changing our PTO and changing a lot of things in our contract, is it still expected to negotiate in that context?
Even more so, because you are a trained employee. They don't want to lose you. You are actually
You're a commodity.
in the driver's seat in that situation than the employer.
Yeah, you have all the leverage.
Yeah.
All of it.
And well, you have the leverage, but you also have this issue of contracts of adhesion, of being forced into signing things. And so let's say they snuck a non-compete into this new contract that was never there before. It's very fair to say, I'm not signing a non-compete unless you give me a bonus of $100,000 or $50,000.
I love that one.
Because
Joe tells people that all the time.
Yeah.
And why?
Yeah. I mean,
Why, Joe?
why? Because you're trading away future income that you have a right to today. It's very different to say, I'll come to your community. I'll serve your community. Our daughter-in-law just started a medical practice in a small town. And it's reasonable for her to say, I will never practice medicine in this community except for you. I will sell my house, move kids and family, and go on, and I'm willing to do that. But if she goes into that community and doesn't have a non-compete, and then somebody forces it onto her, and her husband has a job, her kids are in school, everything else, she is over the barrel. It's just totally unfair. So yeah, I mean, the more they reach out for the contract, the more you ask for. And and that could trim what they asked for. You might be awful disappointed because they take away the non-compete. You've taken away an opportunity to negotiate for this bonus or something. But there's some pretty good law that their lawyer would advise them on. That yeah, if you're wanting big things like non-competes from an existing employee, you'd better do something. On the other hand, all employers in at-will relationships, which is a topic today, can pay you $100,000 a year now, and they'll suffer the consequences if they decide they're going to cut you back and pay you 90 and increase your hours. But they don't want to lose you, and they've suffered through that. But maybe they're in such a pinch that that's what they're going to do, and that's part of what at-will employment is all about.
Other questions? These are good.
I have a question about how the method in which these conversations are had, the context. Are people emailing? Do they set up a time and get that decision maker on the phone? I would much prefer phone because you can get to a yes. You don't have to go back and forth. But yeah, what's the context?
Here's the most successful method, if possible, face-to-face.
Yeah.
If not, virtually on Zoom, where you see somebody. You can read their body language. You have an opportunity to notice gestures, to see how the conversation flows, and you have much more room to be convincing.
Okay.
Next, by phone, and absolute last, and don't even think about doing it, by email.
Yeah. Okay. How many times have you had a text or email that the other person took wrongly? Something came across and it was like, well, that's not what I meant. And you don't want that to be happening with an employment opportunity. So it needs to be, I agree 100% with Ginger.
Well, and as any vacuum cleaner salesman will tell you, you want to make sure that the person you're talking to actually can make that decision.
In terms of negotiating, and not be the messenger.
Absolutely. Absolutely.
That's important.
Otherwise, you get into the used car salesman where they have to go check with their manager on whether you get floor mats. It's just a game.
Intentional game.
That's my other question, and kind of like what I'm running into is like, how do I get the recruiter out of the way?
Tell them you want to speak to the decision maker.
Yeah.
One more random Joe. Time out. One more random drawing. We have about 5 minutes. The Pinard is up now. If you're interested in a hand-turned Pinard, they're absolutely gorgeous. put in a number right now in the chat box, and we'll get that done. And then we'll be finished with the drawings. Okay, go ahead, Joe.
Remember, people like recruiters are a little bit like real estate agents, and they get away with double dealing. They're not going to get paid until there's an agreement, but they can go and share secrets with the employer that they don't share with you, and vice versa. They're not your advocate. They're an intermediary.
I'm not a fan of recruiters. I've used them only when I was really, and it was because the hospital was sponsoring the employer, the person I was going to employ for the first year, and they required it. But we got down to kicking the recruiter out as fast as we could so that we could talk one-on-one.
We have time for one more question, and then I'll tell you who the winners are and how you get your prize. And then we all go watch the debate.
Well, I'll have to make some of this stuff.
I know, Joe. Any questions? Krista?
I do. On RVUs, I know you were saying when I messaged before that you guys are getting away from them, but have you ever seen where they cap your RVUs that you can make?
The money.
The
money.
Well, the money, the salary, not, I guess, I mean, you can exceed.
It's off the one we just read, the last 24 hours said, or whichever is highest. So if you exceed the base, you go with the RVUs added. And if you don't exceed the base, then you get RVUs up to X amount.
Well, because like with my question, with what they're asking now, the RVUs are so low to what I actually work.
Are they over $32 to $35 per RVU?
Oh, well, that is another nightmare we're fighting with them right now about too. But like they want me to work 1,800 RVUs, but I can get up to, I think, 2,200, and they would cap my pay at that. Well, this last year, and I'm part-time, I did 2,800, and I'm well over that for this next year.
Yeah.
So like, what do I just stop working after 6 months then a year? I mean, like, I don't understand how that even makes sense.
You asked to go to a productivity model. That's what I would advise your group to negotiate on, because you're losing out on a lot of money.
Yeah.
By using an RVU model. And I don't know if your group shares it or if you get RVUs by provider, but it can be painful if your RVUs by provider and it's not shared among the group.
We do. Yeah, we do for our all OB is shared. And then the GYN is where we get anything outside the global is our individual.
We know that you can make more money if they're willing to go to a productivity model based on revenue generation. And the integrity of that, which is billables and receivables, and then whatever, they know what you cost. They have some amount of what you cost on an annual basis, and a percentage of that is what you would get paid out in some fashion.
Okay. Thank you.
Yeah. So happy National Midwifery Week. We're glad you all joined us and really are thrilled to be able to spend a little bit of time with you this week. In order to get your prize, please email me because I don't know how to reach you. So ginger@growmidwives.com, and here are the winners. Erin Listerman won the contract review. And again, we need 5 business days to turn those around. So if you have a contract for us to review, remember that. The Vicarious Liability Toolkit goes to Yen. The Grow Midwives coaster set goes to Christina. The 1-hour consult with us goes to Anna. And the hand turn Pinard goes to Nikki. So congratulations to you all. And thank you for being on. This will be on our website probably within 7 to 10 days for people to watch. And if you want to share that with your friends, please do. Thanks again.
Good night, everybody. Good luck.
I'm going to stop